An estate planning client of mine last week mentioned that she's not super concerned about her accounts going through probate because she's added a child to her account. That's also why she felt secure that she didn't really need a power of attorney. Power of attorney authorizes somebody to access your accounts for you if you're unable to do it on your own. Typically, that's what we want, because she had a child on her account. My name is Philip Roos. I'm an estate planning attorney here in Minnesota, and we got to be really careful of this. This is something that comes up a lot. You can absolutely add anybody to your accounts that you want to, but there's three things you have to remember. First off, yes, if I add a joint owner, an adult child of mine, for example, to my bank account, that person will get that at my death. That's great. If I have multiple children, well, no one else is getting anything because the joint owner is getting everything. So that could create some disproportionate transfers and some hard feelings. Hopefully this person is generous and will gift money to their siblings. They don't have to. Also, there can be gift tax issues there. You got to be careful about that because they are now making gifts to people with their money that they inherited by virtue of the joint ownership. So watch out for that. And yes, the person will be able to access the account because they're a joint owner. If I die, the joint owner, it's their money. They can access it for whatever they want to. So that's nice. But always remember this. A joint owner has three things. They have liabilities of their own. This is officially their money, okay? So they have the ability to lose it. If they get sued or something, this is their money. You added them as a joint owner. I hope they don't get divorced. This stuff can cause some problems. Another issue with a joint owner is we've just gifted them the value, half the value of the account. If I have 100 grand, I'm making this up, if I have 100 grand in a checking account and I add a joint owner, I have gifted that person half, $50,000. Might be a gift tax issue, might be a gift tax return, certainly, if I do that. And then the last thing we got to worry about with joint owners, if the asset to which I'm adding the joint owner, it has appreciated value. So I'm not talking about cash, but I'm talking maybe about an investment account. I bought some mutual funds cheap. Now they're up here in value. Well, if I add a joint owner, that other person keeps my cost basis for purposes of calculating capital gains. If I give someone appreciated assets at my death, the cost basis resets to the date of death value and they can sell at capital gains free. Their purchase price is whatever the value was at my death. If they sell it for about the same thing, no capital gains. If I give it to them during life, they keep my purchase price. They keep my cost basis. So if I die, it doesn't reset. They keep this purchase price as their cost basis. So when they sell it, they are now going to have some tax. So we got to watch out for that stuff. So usually if you're worried about someone having access to your accounts, add a signer. Don't add a joint owner. Add a signer. And then make sure you have your power of attorney document set up so someone can access this stuff if needed. That's always my advice. Phil Roos, Stone Arch Law Office. Certainly do write me an email if you have any questions.